Hello, everybody, and good morning. How is everybody today? Happy birthday, Joanne. There's my sister. Hello, Des. Lady D, Mel W, Lisa, Yum Diddly Dum. Hello. Anne's Armchair. Hello. Rosie, hello. Glad that you can all make it. We're going to wait until we get a few people in here, and then we're going to start. Hello, Vera. Letecia is back in court tomorrow, but I've just come across some stuff that had been filed. Hello, Jackie. Hello, Kimmy. Christina S. Hello. This was filed in late November, and I don't know why it just came up on her site now. Hello, Lisa. Hello, Kara. Welcome, everybody. I ask if you please smash that like button on your way in. Doesn't cost nothing. It's free. Hello, Cindy. Drive safe, Cindy. Happy belated birthday, Anne. November 24th. Happy birthday, belated. Hello, Leona. So, like I was saying, Letecia is going to be in court hopefully tomorrow. Hopefully, I can live stream it for you guys. Let's keep our fingers crossed. But if not, I will have information coming out of the courtroom. Hello, Tricia. That I will be able to pass along like we do when we've been banned from live streaming. So you will know everything that is going on, but there's a bunch of stuff that's been filed. So I believe that this is going to be taken up tomorrow also. Hello, Henriette. They're supposed to be setting a trial date tomorrow and also a review hearing because she wanted to be reevaluated again and all this stuff. So hello, Patty. So that's all going to be dealt with tomorrow, and hopefully the trial date is set. She has pled not guilty, so let's see what happens there. I also got a new setup, you guys, for my lives when I'm doing live, well, more or less for my paid private reads, but anytime I go and do any of the public reads now, I've got a different setup here. I got some equipment that just finally came in. I've been waiting for it for a while. So I'm hoping that this is going to be a better setup. Okay, Mitch, and welcome. 65 viewers and only 28 likes. Come on, guys, smash that like. It's free. Yeah, exactly. Okay, let me head back over to StreamYard. I'm wondering the same thing, sister. Oh, we love and appreciate you too, Vera. I like watching Henriette from South Africa. I hope you guys are all well down there in South Africa. I hear there's a really bad new variant going around down there. Know that we're thinking about you and keeping you all in our prayers and hoping for safety for all of you down there. Thank you, Lisa, for smashing that like on your way in. I appreciate it. It also helps you guys with the algorithm, letting everybody know. Okay, that's why I've got top chat instead of live chat. So I'm missing a lot of the chat. So that's why I head over. If I'm not putting stuff up on screen, you guys, it's because on StreamYard, I can go back and forth between StreamYard and the YouTube studio, because my chat goes really fast in StreamYard and I miss a lot in YouTube. In my YouTube studio, I can put on live chat instead of just top chat. So if you guys think that you're missing some stuff, look up top of your chat and click live chat instead of top chat. Ketta Whitley, well, thank you all for being here. It goes both ways. You're very welcome, but I thank you guys all for being here also. My birthday was great, Karen. Thank you for asking. I had a great day. Hangover the next day. My sister seen me in the morning when she FaceTimed me. It was like, ugh. Now I remembered why I don't drink. Okay, so we got about 79 people in here, 74. Please smash that like button. Hello, Mama Bear. Nice to see you. Big hearts. Thank you. Hearts back. Thank you. Thank you. And just to let everybody know, the last live stream that we did, for those who stayed right to the very end, got an extra bonus. Just as Janie and Cat's Meow each won a shirt from my store because they stayed right till the end. A lot of people drop out quickly when I say that I'm going to get offline and whatnot, but we continued chit-chatting on for a bit. Sorry, you guys, I just got an email come in. I had to check that. Yeah, and they ended up winning some shirts. I ended up giving out some shirts. So, hello, Betty Smith, Karen, everybody that I haven't said hello to, hello. And we're going to get into this. Okay, so we got about 82 people in here. Only 60 likes, you guys. Smash that like button, please. And we're going to, while I'm getting this set up so I can show you what we're going to go over before the hearing tomorrow, so you guys are a little bit more informed and know what exactly is going on tomorrow. Tomorrow was just supposed to be the review hearing and to set maybe a trial date, but some other things have been filed. So I want to go over that with you guys. I better take that banner off because we are live. But before we get to that, to tomorrow, I will put at the end of this live, I will go over to my YouTube and, oh, your shirt and hoodie came yesterday. How do you like them, sis? Oh, Rosie, I hope you're feeling better soon, hon. I'm glad that they came. Yeah, so while I'm getting this set up, if you haven't smashed that like button, please smash that like button. I'm going to go to share screen. And I'll make it full screen for you guys. So there is a court date for her tomorrow. Hopefully I will be able to stream it live for you guys. It's Gregory Werner, I believe. I don't know if he is the one that banned everybody or if it was Murphy that banned everybody. But we'll see. I'm hoping, you guys, that I can bring it. Hello, Kitty. Hello, AJ. Good. I'm glad that you love them, Des. Hi, Jack. Hello, everybody coming in. That if I've missed you, I'm sorry. I'm back over on my StreamYards, and the chat does go pretty fast. Also, if you do put up some super chats or super stickers, stuff like that, I can't see them on StreamYard. So I'll get my sister to send me a message so I can put it up on screen and thank you all for it. Because I have to go looking for them on StreamYard. Wakey, wakey, eggs and bakey. Hello. Oh, well, happy belated birthday. Yes, all these Sagittarius people in here. We rock. Well, you all rock, but I got to represent our Sagittariuses. Okay, so let's get into this, you guys. Hello, Doreen. Hello, Megan. Aw, thank you. Love you and miss you too, Megan. I see that you do have a few things that you've posted lately. I want to go over and check them out as soon as I have time. But thank you for popping in and saying hello. I appreciate that. If you haven't subscribed, you guys, go over to Southern Soul Tarot. And her name is Megan. Please give her a like and a subscribe. She reads tarot. I read oracle and my ancestor. But if you want to know what's going on in a case and see a tarot reading on it, she's the best. She explains it very well in terms that everybody can understand. So if you haven't subscribed, head over there and give her a like and subscribe. Let her know I sent you over there. Hello, Doreen. Hello, my dear. So, Megan's going to call you today, Daz. Yes, there's the link for Megan's channel, Southern Soul Tarot. You won't be disappointed. Go on over there and give her a subscribe and a like. Hello, Trisha. Okay, let me just take a quick sip of my coffee here, you guys, and we're going to jump into this. Don't forget, come back tomorrow. I will put the thumbnail up when I'm done this live so you guys can click on that. I'll put it in my community, under my community tab. I'll make a post of it in my community tab, and there's a reminder button right on there that you can click. So you're made aware when I start. Sorry about the coughing. It is what it is. I'm sorry. I will block it out as much as I can. Okay, so let's get going on this. So this was the first, yes. Okay, yes, before we start that, Kat's got my, thank you for that, because I just seen a thing on it. I was going to post it here, but I didn't make the thumbnail about the Delphi things. Somebody had emailed me also regarding the Delphi, that there's some information. Now, the information that I've got, I'll let you guys know since it's been mentioned in chat. Anthony Shots is the fictitious account that was used. Now, they're not saying right now whether this is connected or not. They're not saying too much about that. Cat's got my eye. You just ruined my next live for me. But anyway, yes, his name is Anthony Shots. He was not a person of interest in the beginning. Okay. But what they've come across with this guy is that he was, and some of the pictures are like, ooh, hot, 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 hot. Like that, he's a good looking, making himself look like almost like a 20-something model, like shirtless with the abs, the whole 9 yards, you guys. I've took a little bit of time to look into it. I was going to do a live on it, but I guess we're going to talk about it now since it was brought up. But he had been sending contact information and everything to a bunch of teenagers, trying to get them to interact with him and send him information on themselves on Instagram and Snapchat. He goes by Anthony Shots. We don't know at this point what other social media platforms he used this profile for, but they are looking into it. And they're asking anybody that has ever come in contact with this Anthony Shots to contact them. Like I started setting this all up with the contact information and everything. I'm probably still going to do it, even though Kat let the cat out of the bag on me. And yes, he's been identified as 27-year-old Keegan Anthony Klein. So in 2020 charged with a bunch of felonies, including child exploitation, child pornography, enticing, stuff like that. I'm just going through some of my, yeah, there's a lot here, you guys. He was contacting teenagers. That's okay, my love. That's okay, my love. Just let, I'm good. I probably will still do the live on it, but anyway, and bring you so I can show you guys the pictures of this guy. Like, he's hot, but it's not him. It's a fictitious account. He's used somebody else's pictures. Yeah, a real sicko. And apparently that they have got information where he's tried to entice a lot of teenage females. Now, for them to bring this up, the first thing they said in the release was he was not initially a person of interest. So how they've connected him maybe to these Delphi murders, there's got to be something there. So let me look into it deeper, and I will be doing a live on that and bringing you all the pictures where I can do it like this on StreamYard, so I can show you guys the pictures and everything. I can't do that on the YouTube platform. You can't show stuff, and like you can, but you need OBS. And if you guys know, for those that were here with me a year ago, I just started YouTube about a year and 4 months ago. Although I have been on YouTube since, I think, 2010, just using the platform for private reads. I did finally go public and make my channel about a year and a half ago. So yous that have been with me since the beginning know I did a live on this OBS nightmare, so I could just use YouTube to stream, but forget it. I'm much too old to figure that stuff all out. It's too technical for me, so that's why I'm using the StreamYard. So yeah, I will do a live on that. So I'm not going to give any more information on it right now. You guys are going to have to wait for my live to get that. And I will include all the photos and everything so you guys can see it. I will do that on the live. Yeah, actually, Shannon, somebody convinced me, one of the people that I did private reads for convinced me to start up a channel and do it on these murder cases and stuff like that. Yeah, I think it was called OBS Nightmare. Oh, it was horrible, you guys. It was like horrible. Oh, I don't know why that one came up in the chat, but it did. Thank you very much, Megan. It helps out a lot. Takes a lot of time to get these things. You know, as a fellow creator, it takes a lot to get these lives and everything to go together, and takes a lot of time. So I appreciate the super sticker. I really do. It helps a lot. And most of that, you guys, I put back into the channel. Like I said, my last live, I ended up giving away 2 shirts because people just stuck around to the end. So a lot of my super chats and super stickers go right back into the channel. So I do appreciate that. The super chats and super stickers in the lives that I do like this help me to be able to do more giveaways and stuff like that for you guys. Aw, Megan, you are such a sweetheart. Thank you very much. She took a 10-minute break from hers to hang out with us for a bit. Yes, thank you for that kind donation. I so much appreciate it, more than you know. Okay, so let's get into this, you guys. Watch for, at the end of this live, I will be posting the thumbnail for Letecia's court appearance tomorrow, and I will be covering that live. And I do believe I can stream it, so you guys will be able to see the courtroom. If not, I will be bringing everything that's coming out of the courtroom. I'll be bringing it to you anyway. So let's get into this. So here's some filings. Now we got Barker and Tellini and Joshua Tellini here that are representing her. So they've made a motion to seal and hold confidential jail records of visits or meetings between Letecia and his. Look at this. Like, for these high profile lawyers, like, are you kidding me? His defense team? Letecia, did she get a sex change maybe? I don't know. I don't know, and it is possible at this point. And their agents. Comes now, this is supposed to say Letecia by and through counsel and requests that this court order the El Paso County Sheriff, all personnel at or associated with the El Paso County Detention Center, the 4th Judicial District Attorney's Office, and all agents, associated contractors, or assistants to refrain from disclosing any visitation logs, tapes, records, or any other information related to visitation of Miss Stauch. At least they didn't put Mr. here. By, here he goes again, his attorneys. Wow. Members of the defense team and or their agents as grounds, Miss Stauch states. 1. Miss Stauch has a constitutional right to effective assistance of counsel and privileged communications between and among Miss Stauch and her attorneys. Miss Stauch has fundamental right to completely confidential attorney, expert, and investigative assistance in preparing her defense to the allegations in this case. They cite some different cases here. I'm not going to read all through that. This right is not lessened just because she is incarcerated. 2. Defense investigators and experts must be able to communicate with Ms. Stauch unencumbered. Allowing the prosecution or its agents access to the visitation logs or other such information related to visits is tantamount to allowing the prosecution access to work product and privileged information. Number 3, as it pertains to the prosecution's discovery obligations, Penal 16(1)(e)(1) states that disclosure should not be required of legal research or records, correspondence, reports, or memorandums to the extent that they contain the opinions, theories, or conclusions of the prosecuting attorney or members of his legal staff. This prosecution has also been held to apply to the work product of defense counsel. So they're giving some other cases here that they're referring to. Maybe she's a he in secret. Okay, the 10th Circuit has held A prosecutor's intentional intrusion into the attorney-client relationship constitutes a direct interference with the Sixth Amendment rights of a defendant, and because a fair advisory proceeding is a fundamental right secured by the 6th and 14th Amendments, we believe that absent and countervailing state interests such as intrusion must constitute a per se violation of the 6th Amendment. And then they give the Schilling versus Hayworth. Thus, the court held that when the state becomes privy to confidential communications because of its purposeful intrusion into the attorney-client relationship and lacks a legitimate justification for doing so, a prejudicial effort on the reliability of trial process must be presumed. Number 5. In Schillinger, the defendant and attorney were required to prepare for trial in jail with a deputy present at all times. During trial, it became apparent that the deputy related information to the prosecutor that had passed between defense counsel and the defendant during trial preparations. The 10th Circuit affirmed the grant of habeas relief and remanded the case to the district court for consideration of the appropriate remedy. 6. There is widespread agreement that communications by post between an inmate and his, again, attorney are sacrosanct, subject only to tests on incoming mail for the presence of contraband, which fall short of opening it when the inmate is not present. Oral intercourse has been hedged with similar protection in the Adams versus Carlson. The privacy, according to the attorney-client relationship, must exist even in the prison context. Ms. Stauch makes this objection and all other motions and objections in this case, whether or not specifically noted at the time of making the motion or objection, on the following grounds and authorities: federal and state constitutional rights to bail, due process, to defend life, to the equal administration of justice, trial by jury, right to counsel, equal protection, cruel and unusual punishment, confrontation, compulsory process, right to remain silent, privileges and immunities, and right to appeal clauses of the federal and Colorado Constitution and Article 2, Sections 3, 6, 7, 10, 11, 16, 18, 20, 23, 25, and 28 of the Colorado Constitution. Wherefore, Ms. Stauch requests that this court exclude from trial or sentencing for any purpose attorney-client communications records of any visitation by Ms. Stauch attorneys or their agents. Enter an immediate order that under no circumstances may anyone from the El Paso County Sheriff's Office or the El Paso County Detention Center, nor any agent of the prosecution or law enforcement, shall reveal any information to the prosecution or its agents about visits Ms. Stauch may have with defense counsel, any members of the defense team, or any agents, experts, associates, assistants, or any other persons affiliated with the defense. This includes visitor logs, entries, or any other records or information. 3. Enter an order requiring the prosecution to disclose whether it or any of its agents have already received such information and require immediate disclosure of the same to the defense. And it's signed Joshua Tellini. So that's what now here is the prosecution replying. People's brief addressing issues raised. There's 8 pages here, you guys. I'm not going to read through it all because they're just going to reply to what was just filed. There's 8 pages here. But basically what they're saying here, the people's brief addressing issues raised by defendant's notice of intent to present. Oh, this is different. Okay. Okay, so this is the people's brief addressing issues raised by defendant's notice of intent to present evidence in her mental condition. So comes now Michael J. Allen, District Attorney for the 4th Judicial District, and his duly appointed attorneys are submitting this brief in response to the court's order of November 4th. So I don't see that order, so it must be sealed. On November 4th, through counsel, the defendant gave notice pursuant. Oh, it was through. I believe that was on the live that they brought this up. That's why it's not in the record yet. And I think they ended up sealing whatever conversations they had in private. But they're bringing it up here. So I'm going to go over what they've said. On November 4th, through counsel, the defendant gave notice pursuant to 16.8.107 CSR 21 stating, it is likely that we are going to introduce evidence by mental health expert regarding Ms. Stauch's mental condition after the disappearance of Gannon Stauch. So not during or anything. It's her mental condition after the disappearance of Gannon Stauch. So the defendant gives notice that he or she intends to introduce evidence in the nature of expert opinion concerning his or her mental condition. The court shall order an examination of the defendant pursuant to, and they give the sections. I'm not going to read through all the sections, you guys, because it just takes too long. All examinations ordered by the court in criminal cases shall be accomplished by the entry of an order of the court specifying the place where such examination is to be conducted and the period of time allocated for such examination. The defendant may be committed for such examination to the Colorado Psychiatric Hospital in Denver, Colorado Mental Health Institute in Pueblo, the place where he or she is in custody, or such other public institution designated by the court. In determining the place where such examination is to be conducted, the court shall give priority to the place where the defendant is in custody, unless the nature and circumstances of the examination require a designation of a different facility. The defendant shall be observed and examined by one or more psychiatrists or forensic psychologists during such period as the court directs. For good cause shown, upon motion of the prosecution or defendant or upon the court's own motion, the court may order such further or examination as is advisable under the circumstances. Oh, sorry, you guys. I just had an itch in my throat so bad. I tried to take a sip of my coffee quick and it went down the wrong way. Anyway, Nothing in this section shall abridge the right of the defendant to procure the examination as provided. An interview conducted in any case that includes a Class 1 or Class 2 felony charge or a felony sex offense charge described in Section 18 pursuant to this section must be video and audio recorded and preserved. The court shall advise the defendant that any examination with a psychiatrist or forensic psychologist may be video and audio recorded. A copy of the recording must be provided to all parties and the court with the examination report. Any jail or other facility where the court orders the examination to take place must permit the recording to occur and must provide the space and equipment necessary for such recording. If space and equipment are not available, the sheriff or facility director shall attempt to coordinate a location and the availability of equipment with the court, which may consult with the district attorney and defense counsel for an agreed upon location. If no agreement is reached, and upon the request of either the defense counsel or district attorney, the court shall order the location of the examination, which may include the Colorado Mental Health Institute at Pueblo. Hi, Melinda. I just glanced over, so if anybody sent any more super chats or anything, I appreciate it. I will try and scroll up here. Let me scroll up. Thank you again, Megan, for your super chat. I appreciate it. Thank you for supporting. Thank you to everybody coming in. Headed back to work. Have a great day, Megan. Thank you for popping in, and thank you again for your super chat. Rosie says, I really want to say something crude there, but I won't. Hi, Alia sisters. We love you too, Melinda. And thank you for your order. I seen it pop up there. Thank you so much. For some reason, I cannot pin my merchandise today for some reason, but oh well. My mods will put it in the chat if you want to go. And don't forget, you guys, if you don't order by the end of this week, if you do want to order, you won't have it in time for Christmas. Oh, thank you, Cindy. Cindy got her shirt too. Thank you. Cindy sent Des and I a little something. I appreciate that. Okay, let's get back to this. Okay, Pueblo. Give me a second, guys. That was Mama. That was Mama. Okay. The defendant shall cooperate with psychiatrists, forensic psychologists, and other personnel conducting any examination ordered by the court pursuant to this section. Statements made by the defendant in the course of the examination shall be protected as provided in Section 16.8.107. That's why my throat is going dry on me, you guys. I've got a heater going here because it's really cold where my office desk is set up. I can freeze for you guys to bring you this. It wasn't me. No, it wasn't you. It was Mama. But yeah, I had my heater going because it's really cold where I'm sitting. And that's what's drying out my throat and my eyes. Okay, here we go. Okay, so the course of the examination shall be protected as provided in Section 16.8.107. If the defendant does not cooperate with psychiatrists, forensic psychologists, and other personnel conducting the examination, the court shall not allow the defendant to call a psychiatrist, forensic psychologist, or other expert witness to provide evidence at the defendant's trial concerning the defendant's mental health condition, including but not limited to providing evidence on the issue of insanity or at any sentencing hearing held. Now, she just screwed herself, okay? Because if she doesn't cooperate now, anything to do with her mental health will be thrown out, and they will not be able to call their own psychiatrists or forensic psychologists or anybody conducting any kind of psychiatric evaluation on her. And they list a lot: forensics, everything. And they won't be able to call one either during her trial or sentencing. Rosie says, I have my heater on and it's summer here. Oh, so now it's going to be up to the court to decide who does this examination of her. So she doesn't go to this examination or doesn't answer their questions and stuff like that, then they can't call any psychiatrist or psychologist or anything in her defense. Was she not no, she wasn't cooperating, Does. Half the time she wouldn't even come to court. So she's going to be forced here now to cooperate, okay? Or she's going to lose the right to be able to call any psychiatrist or anything in her defense. Okay, so where were we here? Where we leave off? Okay, so okay, so she won't be able to call anybody concerning the mental condition, including but not limited to providing evidence on the issue of insanity or at any sentencing hearing held pursuant to Section 18, 1.3, 1201 for an offense charged prior to July 1st, 2020, or pursuant to Section 18, 14102. In addition, the fact of the defendant's non-cooperation with psychiatrists, forensic psychologists, and other personnel conducting the examination may be admissible in the defendant's trial to rebut any evidence introduced by the defendant with regard to the defendant's mental condition, including but not limited to the issue of insanity, and in any sentencing hearing held pursuant to Section, and I'm not going to read them all again, for an offense charged prior to July 1st and applies or pursuant to Section 1814 and applies to offenses committed on or after July 1st, 1999. Regardless of whether a defendant enters a plea of not guilty by reason of insanity pursuant to this section, the defendant shall not be permitted to introduce evidence in the nature of expert opinion concerning his or her mental condition without having first given notice to the court and the prosecution of his or her intent to introduce such evidence and without having undergone a court-ordered examination. Pursuant to the section, a defendant who places his or her mental condition at issue by giving such notice waives any claim of confidentiality or privilege as provided in Section 16.8. Such notice shall be given at the time of arraignment, except that the court, for good cause shown, shall permit the defendant to inform the court and prosecution of the intent to introduce such evidence at any time prior to trial. Any period of delay caused by the examination and report provided for in Section 16.8 shall be excluded, as provided in Section 18.1.4056A CRS, from the time within which the defendant must be brought to trial. A defendant who places his or her mental condition at issue by pleading not guilty by reason of insanity pursuant to Section 16.8 or disclosing witnesses who may provide evidence concerning the defendant's mental condition during sentencing hearing held pursuant to Section 18 for an offense charged prior to July 1st, 2020, or pursuant to Section 18.14, or for offenses committed on or after July 1st, 1999, by seeking to introduce evidence concerning his or her mental condition pursuant to Section 16.8, 107, waives any claim of confidentiality or privilege as to communications made by the defendant to a physician, psychologist in the course of an examination. So they're just going over that she will not be able to enter any of this as a defense. If she doesn't go along with this examination. Separate opinions as to whether the defendant was insane or is ineligible for release, as those terms are defined in this article, 8, and in any class 1 felony case for an offense charged prior to July 1st, 2020, as an opinion as to how mental disease or defect or the condition of mind caused by mental disease or defect affects any mitigating factor. The nature of the opinions required depends on the type of examination ordered by the court. Now, here is, hang on. Here's what's interesting, because I think the death penalty, if you were charged with an offense prior to July 1st, 2020, you could still face the death penalty. Now, I don't know if they're going to do that in this case, because it's just going to prolong it even more. And death penalty cases now have been, they don't do them anymore. They don't carry out executions anymore for death sentences. So if she would just be, for the rest of her life, she's going to be in jail. So I hope at this point, we've seen how that's happened with Lori and Chad. We had a trial date set, and then prosecution came in a couple months after the trial date had been set and said, we're going to apply for the death penalty. We want the death penalty in this case. Death penalty is still active in that state. And what it did was, now this trial date is put off until 2023. The trial should have already have started, but because the prosecution came in wanting a death sentence, it put everything up in the air again. So I don't think they are going to go for the death penalty, because it won't be carried out anyway. But I do believe they're going to go for the rest of her life in jail. Hello, Sammy Smith. Welcome. Hello, LC. Okay, so that's why this is an issue. The nature of the opinions required depends both on the type of examination ordered by the court. Okay, separate opinions as to the defendant's mental condition, including but not limited to whether the defendant was insane or ineligible for release. They're going through this again. In no event shall a court permit a defendant to introduce evidence relevant to the issue of insanity as described in Section 16.8 unless the defendant enters a plea of not guilty by reason of insanity. Now, she didn't enter a not guilty by reason of insanity. She entered a plea of not guilty. The reason that she is saying that she wants to claim insanity is she wants to say that she was insane after the fact. After the death of Gannon, she became insane. So, in other words, in my opinion, she's going to say everything that I did with hiding his body, with transporting his body and throwing it under the bridge and everything that she did, I wasn't in my right state of mind. I shouldn't have done it. So when maybe out of anger, this is what I did, and he was killed, but then she's going to try and say somebody else killed him. But when she seen that he was dead, oh my God, she freaked out thinking she's going to be held responsible. So she took his body and did what she did with it. That's what I think she's going to do. She is going to say, I did not kill him. Somebody did, but I did find his body. And then I did do what I did afterwards, but I was not in the right frame of mind. Remember, I said that right now, you guys, before anything is said by her or her attorneys or the courts or anything. This is what I'm saying. This is what I think she's going to do, is she's going to say that somebody else killed Gannon, but yes, she did find him. Accessory after the fact she wants. He was dead when I found him, but what I did afterwards, that sent me into a mental frenzy and I lost my mind and I figured everybody would blame me. So I took his body and I did what I did. That's what I think she's going to say. What do you guys think? But this is what I think she's going to say. Is that somebody else did it, but she walked in and found him. And then fearing that she would be blamed for it, she cleaned up the mess and got rid of him. Yeah, but Des, I don't think she's going to, she's pled not guilty to murdering him. So she is going to blame somebody else for murdering him. She's going to say, I went down in the basement. I found his body, this Eduardo or whoever. She's even trying to blame Al. Somebody else killed him. But I did clean up the mess because I think that I would be the first one they look at and maybe be blamed for killing him when I didn't. That's what she's going to say. Mark my words. Harry Cow. I'm not saying that's what she has said. I'm saying this is my opinion on what I think she is planning on doing. She has pled not guilty. She is going to say that somebody else killed him. She walked in and found him, and she lost her mind, and that's why she did what she did with hiding the body and all that. That's my thoughts only. Let's see what happens come trial. Well, she's blamed somebody else all along, but this is what I think in the end she is going to, because now she knows that they have found the evidence of the blood and everything in the house. So this is exactly what I think she's going to say, is that somebody else did it. She came upon it and went insane. So thinking that she would be blamed for it, she just covered it all up and hid his body. That's what I think she's going to say. Yes, she drove him across state lines too, so there it's major. Okay, so let's continue here. The defendant's court-ordered mental health examination should take place at the Colorado Mental Health Institute. Now, I'm not going to read through all of this, you guys. They're going to cite cases here, but what the prosecution is saying here is this is where they want the evaluation or examination held. Okay? And they're going to give their reasons why. And they're saying, although the statute states that the court shall give priority to the place where the defendant is in custody, the court may designate a different facility if the nature and circumstances of the examination require it. So they're saying that she can't get a proper evaluation within the jail itself. So they want her evaluated at the Colorado Mental Health Institute at Pueblo. And they say here the court should exercise, and I'm going slow here, so if you guys do want to pause it later and read through this, you're more than welcome. The Colorado Mental Health Institute at Pueblo, the place where he or she is in custody, such other institution. You can read through all that if you want. But here the court should exercise its discretion to order that the defendant's examination occur at the Colorado Mental Health Institute at Pueblo. Given the nature and circumstances, the attendant to that examination. Oh, cat's got my eye. Thank you so much. Every little bit helps. Thank you so much for that. And like I said, all you guys, I just happened to catch that out of the corner of my eye on the YouTube. All the stuff that I get like that, you guys, I put back into giving away free shirts and hoodies and stuff like that. So I do appreciate that. Thank you again, Cat's Eye. Mwah. Big kisses. Okay, so here the court should exercise its discretion to order the defendant's examination occur at the CMHIP, given the nature of the circumstances attended. And also, don't forget, you guys, that she's tried to escape multiple times. She assaulted a deputy when she was being brought back from North Carolina. She's tried to escape from the jail, so they're going to have her in a secure facility and not being brought maybe out to an outer building to meet with examiners and stuff. Okay, so given the nature and circumstances attendant to that examination, CMHIP is a secure facility that routinely conducts these types of evaluation on defendants facing first-degree murder charges. CMHIP is in the best position to conduct this evaluation, as it is staffed with numerous psychiatrists, psychologists, nurses, and other staff members, capable of observing the defendant for 24 hours a day during the pendency of the evaluation. If the evaluation is conducted at the jail, there would not be an observation period as required by statute. In addition, the hospital is also the best position to assure that the interview portion of the evaluation will be recorded pursuant to statute. Number 3, the hospital also has the best resources available to evaluate as to whether the defendant has a mental disease or defect that rises to the level of legal insanity, or if relevant, any mental condition evidence that may exist based on the broad, vague nature of the defendant's notice given. Okay? So by placing her mental condition at issue, the defendant waives all privileges applicable to communications with physicians, psychologists, including the attorney-client privilege. So as you've seen in our last documents that we went through, they want to seal that. They don't want the prosecution being able to see this stuff. Well, by her putting her mental condition at issue, she's waiving that privilege. Okay? So under Colorado law, a party who places in issue a confidential communication going directly to their claim or defense waives all privileges with respect to that communication. In a criminal case, an accused asserts a mental status defense waives all privileges applicable to communications with physicians and psychologists, including the attorney-client privilege, in the section which provides that a defendant who places her mental condition at issue waives any claim of confidentiality or privilege as to communications made by the defendant to a physician, a psychologist, in the course of an examination for the mental condition for the purpose of any trial. Good morning, Marie. Yes, lots of extremely, the most heinous and violent people have gone through this facility to be examined. Good morning, Marie. Have you got your sweatshirt yet, your hoodie? Okay, sorry, you guys. Whoever just did that, or did I get that super chat already, that sticker? I did. Okay. So they're just going over, if you guys do want to read through this, you can pause it and read through it. But they're just giving different cases that they're using in their decision and the stand that they're taking on this. Okay. So in this case that they've talked about up here, Gray's unequivocal on 2 points. First, a defendant who asserts a mental status defense waives all claims of privilege to records and testimony pertaining to medical examinations pertaining to medical condition that are prepared for use at trial. And second, the waiver of privilege is broad and encompasses all communications and records, including those that pertain to matters that predate or postdate the offense. The purpose for such broad waiver is based on the need to discern the truth regarding the defendant's mental state when the crime was committed. To serve this purpose, both the prosecution and the defense need full access to everything in the examination reports. Well, you should be getting it soon, Murray. Okay, defense counsel's attempt to limit the scope of the defendant's mental status defense in no way limits the scope of her mental examination, which may go into matters that predate or postdate any of the crimes charged or the people's access to the results of that examination on this matter. On this matter, the Gray opinion interpreting the plain language of Section 16.8.103 and plain language of Section 16.8.103.6 are clear. The right to claim the attorney-client and physician-psychologist patient privilege are waived, as is any objection to pre- or post-offense information concerning the defendant's medical condition. So they can't have it both ways here. You can't say, oh, when she found, because this is, like I said, you guys, you know what I've said. I think she's going to say she found him dead. Somebody else killed him. And then she lost her mind. And that's why she did what she did with his body and took it from the house instead of reporting it. Any normal person would have called the cops, right? Look I just found my stepson dead. Somebody came in and killed him. No, it's not what she did. She's saying she didn't kill him. And what she did after the point of finding his remains, well, and this is in my opinion, you guys, my opinion only, please keep that in mind. I believe she is going to say that somebody else killed him. She found him, lost her mind, went totally insane, cleaned up everything, and did what she did afterwards with his body. So if you're going to claim now that she found, since his death is when she went insane, like, what? No, not going to fly. If I can see what is, like I said, it's my opinion, but I can see through this defense's bullcrap and what Letecia's trying to pull. And this is what I think she is going to try. This is going to be the defense. Remember she said she had an ace in the hole? Remember that, you guys? Way back, I got an ace in the hole. She is going to try and pin the murder on somebody else, in my opinion, and act like she walked in and found him dead. Panicked, thought she'd be accused of being the one who killed him, so she cleaned it up and did what she did with his body. That's what I think she's going to say. Don't forget, she says she's got an ace in the hole. That's what I think it is. Okay? Hello, Babs. Welcome from Washington State. Melinda says she believes that Harley's going to be her ace. I don't think so, because I don't think so. Because Harley wasn't there. Harley was at work, and that has been proven. I think she is going to say, if you want my honest opinion, and please don't put this out there as fact because it's my opinion, she is going to say that Al owed money to people, and that's who killed Gannon. Somebody that is involved with Al somehow. That's what I think. Okay, let's continue. Before the defendant submits to a psychiatric or psychological examination, she must be advised about the risk to her rights that such an examination will entail. Don't forget, we're in court with her tomorrow, and I will be bringing you guys that live. It starts at 3:30 p.m. Eastern time. Eastern time, you guys. Right now, it's 1:57 p.m. Eastern. It starts tomorrow at 3:30 p.m. Eastern time. I will be bringing you this live tomorrow, her court appearance for Letecia Stauch. Valdera, hello, and welcome. Hello, Titan. Okay, so let's go back over here, you guys. Okay, so the Colorado Supreme Court has held that the trial court should advise the defendant of the consequences of submitting to a court-ordered sanity examination. Namely, the people may use evidence acquired directly or indirectly from any communication made by the defendant during this examination to rebut any evidence offered by the defendant at trial regarding her ability to form a culpable mental state, or to impeach or rebut any testimony by the defendant. See the People versus Branch. Okay? The court has applied this holding to other types of examinations as well, competency exams. Okay, the holding of Branch is broad and can be read to apply here as well, for the reason the court should advise defendant in advance of any examination of the evidentiary consequences of statements made by her during the examination. For purposes of computing defendant's statutory right to a speedy trial, the period of time from the point she is committed for observation to the point the final report is filed, if filed within a reasonable time, is excludable. Both the speedy trial statute and the applicable, having a hard time today, you guys. Rule of criminal procedure require the discharge of any defendant who is not brought to trial within 6 months of pleading not guilty. But for purposes of the 6-month period, both the statute and the rule exclude any period which the defendant is under observation or examination at any time after the issue of insanity, incompetency, or impaired mental condition is raised. Section 18, which excludes the period of any delay caused by the instance of the defendant. At the defendant's advisement hearing, defense counsel argued that only the time that defendant is under observation as part of a psychiatric or psychological examination is excluded from the 6-month speedy trial period. Defense counsel's position is contrary to that of the Colorado Supreme Court, which held that the period from the time of commitment until the filing of the final psychiatric report, if filed within a reasonable time, is excludable for purposes of the 6-month period. In addition to the exclusions from the speedy trial statute that apply under Section 18.1.405, they give a bunch of them for examinations due to issues pertaining to the mental condition, and for delays caused at the instant of the defendant. So when you, after your arraignment and everything, they've got 6 months to bring you to trial. Now, if the prosecution does something that puts that outside of the scope, you could get a mistrial. You could get it thrown out. But if the defense side does something to prolong this period and brings it that you can't get to trial within 6 months, then they have waived the speedy trial. The 6-month timeline starts all over again from the time that everything is received from that. They have now another 6 months to bring her to trial from the time that they get the final report from this evaluation. So because it's the defendant prolonging this, this cannot be thrown out for not getting a speedy trial. Okay? Because the defendant has not entered a plea of not guilty by reason of insanity, this court must exclude any evidence at trial that is probative of insanity. Oh, thank you, Cat's got my. Thank you for the sticker. Helps a lot. Thank you very much, you guys. I appreciate each and every one of you. Okay, so when a defendant gives notice under 16.8 that she intends to introduce expert opinion concerning her mental condition, the court shall order an examination of the defendant under 16.8, and that's what they did at the last hearing. Okay, they're going to say, well, it's not during, it's not before, it's what happened when she found him dead. Okay, after his death. Doesn't matter, still applies. Okay, so it cites the sections, but evidence attained from that examination is not necessarily admissible at trial, where, as here, the defendant has not entered a plea of not guilty by reason of insanity. She just entered a not guilty plea. She didn't enter by reason of insanity. The trial court must exclude any evidence that is probative of insanity, and that term has been defined by the legislature, irrespective, okay, for the purpose that it's been intended. So they're just listing a bunch of things here about the more and how this has been applied in other cases. So like I said, you guys can go through this if you want. Okay, so there it is there. Blah, 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 blah. Okay, so evidence that is relevant to the issue of insanity is evidence that tends to prove or disprove the issue of insanity. That is evidence that is probative of what is defined as insanity. Therefore, under these sections, which defines insanity, the court must ask whether some or all of the proposed testimony tends to prove that the defendant was so diseased or defective in mind at the time of the commission of the act to be incapable of distinguishing right from wrong, or suffered from a condition of mind caused by mental disease or defect that prevented the defendant from forming a culpable mental state that is essential element of a crime charged. Hello, and history underfoot. Okay, evidence of less severe mental illness than insanity may be admissible in the absence of an insanity plea, but only if it conforms to the statutory requirements and rules of evidence. Therefore, once the results of the defendant's court-ordered examination are complete, this court will be required to parse and proffer mental condition evidence, line by line if necessary, to distinguish what is probative of insanity under the exacting definition from what is not. She's defective, all right. And the evidence generated by the defendant's examination is relevant to the issue of insanity as defined in Section 16.8. That evidence is not admissible at trial because the defendant has not pleaded not guilty by reason of insanity. So it's all irrelevant. That evidence is not admissible at trial because the defendant has not pleaded not guilty by reason of insanity. Okay? Holding that evidence of the defendant's bipolar disorder, which he offered, and this is in this other case here, in the People versus Rosas, holding that evidence of the defendant's bipolar disorder, which he offered to show that he was incapable of forming a culpable mental state, was also relevant to the issue of sanity, and thus inadmissible in the absence of a not guilty by reason of insanity plea. So she better be careful on what she's doing because she could be sealing her own fate. Okay? So that's what they have filed, and now we've got the final one here. Like I said, you guys, for those of you who have just joined, I believe, and this is only my opinion, she is going to say somebody else killed him. She's not saying she was crazy before Gannon was killed. She's saying she became insane after. And the reason that I think she is going to say is she's going to say that she went down into Gannon's room and found him dead. Somebody else killed him. And when she seen that, it sent her in such a mental state that she lost her mind. She cleaned everything up and disposed of his body. But it wasn't her that did it because she has pled not guilty. She did not plead not guilty by reason of insanity. She pled point blank not guilty. So she could be opening up a rabbit hole here that she does not want to go down. Like I said, we are going to see what's going on tomorrow when she is in court tomorrow, 3:30 p.m. Eastern. Be here because I'm going to stream it. So let's get this last one here. Unnumbered defense motion filed on November 11th. People's response to defendant's motion to seal and hold. Oh, here it is. We did go through this one here. The motion to seal and hold confidential jail records. Okay, so here is the prosecution answering to that now. People's response to defendant's motion to seal and hold confidential jail records of visits or meetings between Letecia Stauch and her defense team and their agents. Oh, they just go through the blah, blah, blah up here. The defendant fails to demonstrate how reviewing public records from the El Paso County Criminal Justice Center violates attorney work product, or how reviewing those public records gives the people access to confidential communications. The names of people visiting a defendant in jail are not work product. Okay, and they give an example where the court has addressed this in the past during another trial, the People versus Small. The court addressed attorney work product and stated, contrast to the privilege against self-incrimination, the work product doctrine is not of constitutional origin and is considerably more limited in scope. Its purpose is to protect the attorney's thought process from discovery, therefore affording him the opportunity to prepare a client's case free from the unnecessary intrusion of opposing parties and their counsel. Okay, so this case, Hickman versus Taylor, provides that disclosure to the defendant shall not be required of legal research or records, corresponding reports, or memoranda to the extent that they contain the opinions, theories, or conclusions of the prosecuting attorney or the members of his legal staff. The work product of a defense attorney is similarly protected from disclosure. 2. The attorney work product doctrine is limited, as stated by the Colorado Supreme Court in Richardson versus the District Court. When an attorney claims that something is work product, the courts have held that there should be an in-camera review by the court to determine if the item is actually work product. And they give the different cases here that they are referring to. That has already been a decision or judgment has already been made. That's why they comment on cases like this. They use them as another case that has already been decided by law. And that's what they are referring to. Okay, so defense asserts that access to these public records and jail logs amounts to having access to confidential communications and work product. However, the jail visitor logs themselves contain no record of communications between the defendant and her defense team and their agents. Further, the people do not have access to any communications between the defendant and her defense team. So that is what he replied. So what basically they are saying, when the defense said that they don't want the prosecution being able to, let's get out of here now. The defense had filed a bunch of motions saying that they don't want the prosecution being able to see these records, who's visiting her and all this and blah, blah, blah. Well, they can't do it. It's public record. Now, by the prosecution going to the jail and saying, okay, I want to see her visitor list, that visitor list doesn't come attached with verbal or visual recordings. All it says in that log is so-and-so visited Letecia Stauch and the privilege, if there's any privilege there. It doesn't give them a copy of a recording that may have been made of it for security reasons. It doesn't give no audio or video recording attached to that. It just says who was there. That's public record. My throat is so dry. You know what? I figured it out, you guys, because when I'm talking a lot, especially reading over documents, and then I start hacking and coughing, I couldn't understand why, because I'm good. I've had x-rays and COVID tests, and I'm good. It's because of this dang heater I've got right below me, because it's so cold in the corner of my office here where I've got my desk. So that's what's causing my throat to go dry. So I won't be doing that. My nose is all dried up now too. Yes, Rosie. Police go over prison logs to investigate cases all the time. Yes. And so do the prosecution. Like, is Al going to visit her? We know he's not. But you know what I mean? They want to know who she's visiting. Wouldn't we all like to know that, Sammy? So yes, she is in court tomorrow. And I will be streaming that live tomorrow, I will be online at 3:15 p.m. tomorrow afternoon. The court case is supposed to start at 3:30 p.m. tomorrow afternoon. Once I'm done this live, I will go and make a thumbnail for it and put it up in the community. I'll post it in the community tab as a post, so you guys can click on the reminder right on there. Rosie says a humidifier. Rosie, I have a big, huge humidifier about 20 feet from me, but it kind of the heater, putting the heater, I have to put it right below me at my feet, and then it comes up under my keyboard and up into my face because my feet get so cold sitting here for long periods of time. and it takes some time to bring this stuff to you guys. So I have to have that heater going to keep my feet warm. But that's what's drying out my throat. I do have a humidifier, and it's going 24/7. So, okay, Melinda, thank you for showing up, darling. Love you. Yeah, hopefully it's streamable. I believe that it is. I think that it is. But either way, I'm going to be having the information because I will have information coming out from those in the courtroom. So I will be putting that all here too. Love you too, Melinda. Thank you for stopping in. So tomorrow, 3:15 p.m., I will be going live and covering Letecia's court appearance tomorrow. There's a review hearing, and I believe that they're going to be setting a trial date. Yes, I will be doing a thumbnail for that and putting it as a post. I'll also put it on my Facebook and my Twitter. It's for tomorrow, 3:15 p.m. Jack says, I put my feet on bubble wrap. Sounds crazy, but it works. Yeah, I've got a draft that's coming in behind me around my baseboards, and I wanted to get to it this summer, do some caulking and that around there, so to stop that from coming in, and been so busy, I just never got to it. So I'm paying the price again, but you guys are worth it. Oh yeah, Rosie, I'm good. It's just from sitting so much. My feet are always cold. In the winter, forget it. My feet are cold. But once I get under my blankets and that, they warm up really quick. But yeah, they've done all kinds of. I had a mini stroke a year and a half ago, and they did do all those pressure tests and everything, and put dye in my blood and everything to make sure everything was going good. But yeah, everything was good. It's just that I've been like that since I'm a kid. My feet are always freezing in the winter. And this draft coming in behind me doesn't help. Same as my hands and my nose are always cold. Okay, you guys. So I'm going to let you guys go for now. You now have the documents that I believe they will be brought up tomorrow. So be prepared for quite the hearing tomorrow. It starts at 3:15 in the afternoon, my time, Eastern. Oh, good time to end the live. The dog across the street is out front barking its head off like crazy. So thank you for those who gave the super chats. Again, I appreciate you to the moon and back. Thank you very much. Yeah, my nose is always cold. Daz, you're from Florida. You're used to being like 78 degrees to my sister is freezing. And here I am out yesterday. We got a ton of snow and then freezing rain and then rain, and now our snow's all gone, but we're in for another storm. Thank you, Cat's Eye, again. Cat's Eye, you rock. Thank you. Went out and had to shovel and everything, the stairways and everything. I did it in just a sweatshirt. That's how much it had warmed up. It was like 12, 14 degrees out yesterday, so it melted everything. Rain came, and then it got cold again, and then freezing rain came, and now we're in for another snowstorm. So it makes talks with a heater in them, Christina says. Thank you again, Cat's Eye, for that super chat or super sticker. Thank you. I appreciate you. Freezing here in Saskatchewan. I hear Alberta and that's got it bad too. And Northern Ontario was getting it really bad too. My sister says anything under 80 is cold. Anything under 75, she's freezing. Me, I'm good. I keep all winter long, I keep my house between 65 and 67, 68 maybe. And I get hot. Thank you for sending me that, sister, but I do have that already. I was already working on it and trying to get a lot of it done before this live. Yes, so you guys watch for the video I'm going to do on the Delphi murders. I'm going to do that one too. Like I said, somebody brought it out here, got ahead of me a little bit, but I was going to mention that I will be doing the Delphi murder update. I've also got, let me just see here, you guys. Let me just see here. Yeah, I also, have the updated read for Suzanne Morphew also that I've got to get done. I'm just checking something here, you guys. Okay. Hello, Bubsy B. Hello, Kimmy. Cat's got my. I love that name. Cat's got my. Cat's got my. Where is she? There she is. Ooh. Bubsy says, hello, my Canadian sister. I hope you're having a great week. I am. Been very busy. I'm trying to do family stuff, stuff with my income tax. I've got a lot of paperwork, you guys, to do to get that all ready to go over to my accountant. It's a crap load of paperwork. That time of the year again, coming very soon. So I have been really busy trying to get things ready for Christmas. It's my turn this year to do the big Christmas dinner, so I'm trying to get things organized for that. Yeah, the Summer Wells case it's gone haywire, you guys. Oh, Vera Ray, we're sending you love and prayers, my dear. Hello, Nana. We go one, we go all. Hello, hello, and you're very welcome. Thank you for being here. Michelle, hello from Sydney, Australia. Wow. Kimmy's going to go back and watch from the beginning. Where is she? There she is. I love you too, Marie. Happy birthday, Michelle. Happy birthday. Hope you have a wonderful day. Okay, so we're going to wrap this up, you guys. I will see you guys tomorrow for Letecia Stauch's court appearance. I will be live at 3:15 p.m. Eastern. The court starts at 3:30, just to get everybody in and everybody set up and ready to go so you guys don't miss anything. 3:15 p.m. I will be going live. So I will see you guys all then. Thank you for coming in today. Thank you so much for your super chats and super stickers. I appreciate it. AJ, hello. Yes, good luck to her on that one. It ain't gonna fly. We know that. We're smarter than the average Leticia's. I was gonna say the average bear, but that brings up a whole new case. Bear. Oh, might as well bring that up while I'm here too. I will be going live tomorrow, Letecia Stauch's court appearance. Tomorrow, 3:15 p.m. Then the next one will be on the 14th, Barry Morphew. Be going live at 3 p.m. Eastern on that one. So, yes, happy birthday to all the Sagittarians. I hope you all have a wonderful day. Thank you, all of you, for being here. There's Lady of Angels. Hello, Lady of Angels. There's History Underfoot. Okay, so I'll see you guys all tomorrow. You're very welcome, Jack. See you all tomorrow, 3:15 p.m. right here, same place. See you all tomorrow. Take care of yourselves. Please stay safe. Love you to the moon and back. See you guys tomorrow. Bye-bye for now.